staying for listing of a matter on Friday matter. 26 November 3rd.
Motion matter.
No, right.
Which year?
2018 matter.
18 matter. Okay.
Data matter come for April matter tomorrow.
Wait, please, your Lordship, I beg to mention review petition 125/23, Lordship. Lordship, I will list the matter on Thursday.
Thursday will be 14th. 14th.
Okay. Lordship, I'd like to mention item number 40 of today's topic.
1440.
40. The matter has become infrastructure. Maybe close the
Other side?
other side notice was issued only.
Hmm?
Other side there is no council notice was issued.
No. M. Sharma,
Oh,
P. Agarwal. There are names shown.
they might have entered it.
No. Have you informed them?
No.
We'll pass orders, but in their presence, if we can get them, we want to record their name, in fact. Okay? Get them, we'll pass orders.
May it please your Lordship,
Yes.
may it please your Lordship, I beg to mention for listing a matter for motion for witness paper. Obliged paper.
Have you filed already?
Lordship, yeah, Thursday file.
Back to mention an urgent matter for listing or not. The demolition matter got. May it be listed tomorrow.
Demolition.
Yes.
Is it before this bench? Bench 5 matter.
Best 5 matter. Acquisition of land.
Demolition of what?
Actually, the petitioner is running a big clean, and without proper notice, NHD still has started demolishing the property lot.
After an acquisition process.
And the acquisition order was not at all clear, and the wrong dark
Okay,
number
we'll see. Let us see tomorrow.
more.
May I please tell us? I beg to mention for withdrawal on 30.
Please, item number 20, Lordship, Mr. N. Decker is appearing for response number 5.
20.
20.
Two zero Prasanta Gogoi.
Yes.
His name is not there. He's appearing. Have you
He's
informed the
appearing.
other side?
Yes.
I'm going to petition.
Okay. Please before any other bench without me.
Lordship, the matter may be taken up on Wednesday.
We'll not pass any orders.
May I please, your Lord? Lordship, beg to mention one item for listing, your Lord. On next Monday, your Lord.
Just a minute. This court has been informed that Sri N. Decker, Learned Counsel appears for the response number. Mr. Gogoi, for response number?
5.
5. Club shot, huh? Please. Okay. Yes.
May I please, your Lord? Lordship, beg to mention one item for listing, your Lord. On Monday, your Lord. Next Monday.
Admission matter.
Yes,
Which year?
23, your Lord.
2020?
Your Lord.
What is the urgency?
Urgency is there, your Lordship, in the admission stage, but there was a impediment petition, and the impediment petition was allowed, your Lord.
Not a matter of mentioning. Okay. Sorry. Yes, next.
Yeah, please, Lordship, I beg to mention item 37 to this week. Lordship, 2 weeks time may be allowed to file reply.
37.
So, not big file, but about 30.
You want time for filing rejoinder affidavit?
Yes.
You have already filed your affidavit.
File
When did you file your affidavit?
last week.
Last week.
The past
Lordship, we receive it on 27 to 20.
We have to give them a reasonable period. 10 days. 10 days. We'll fix a date.
Lordship,
You are A.
actually,
Sharma.
Yes.
Sri A. Sharma, Learned Counsel for the petitioner. Prays for some time to file rejoinder affidavit. Para. Sri Goswami, Learned Counsel appearing for the Transport Department. However, submits that there is urgency in the matter. For the para. In the interest of justice, list on 11th, no? A list on 22nd March, by which time rejoinder affidavit may be filed. 22nd March. Interim order.
Yes.
Interim order passed earlier to continue till the next date of listing.
May
All
please,
right.
your Lordship, I beg to mention for listing of a matter for admission on Friday, Lordship, 23 to 23 matter. Lordship, it was last listed on 10th of August.
What is the matter about?
It is a matter for eviction matter of tribal wealth matter.
Education matter, why?
Eviction
This-
matter.
Eviction.
Tribal
Eviction,
wealth.
eviction matter, is there an interim order?
interim order, Lordship. I am on behalf of respondent number 5, Lordship. The matter is last listed on 10th of August and it was directed to list on after 4 weeks. Thereafter, the matter was listed on 3rd of January,
Okay, okay.
but this was not taken by
Okay.
Mr. M.
We'll have it on 20th. Next 20th, 20.
May I please?
No, not 20th. It will have it on 18th,
18.
Monday, next Monday.
But I'm paying for this. For,
Have you filed?
yes, sir.
What is the matter about?
The land acquisition method, within acquiring the land, which is proper, that is
Okay, we'll have it day after tomorrow. Wednesday.
13.
Day after tomorrow, yes, 13th.
May I please, your lordship, I beg to mention item number 13, your lordship, madam,
1-3.
1-3, matter may be taken up after 2 weeks, your lordship.
You
I'm
for-
on behalf of S. Roy,
Okay, motion matter.
motion matter.
Revenue Department, have you informed? There a counsel for revenue, madam? Okay, we are having it next week. Okay. On a prayer made on behalf of the petitioner, list after a week.
Okay.
Item number 13.
May I please, your lordship, item number 31 with 32. Let the item be listed after 1 week. My senior is out of station. I'm on behalf of water resources.
Okay, have you informed the other side?
Yes, your.
I will pay.
Okay,
Petition.
after a week,
After a week,
it is
Interim order
submitted.
definitely.
That's why RM Das Learned Standing Council Water Resource is out of station, full stop, para, list after a week. 31, 32.
interim order.
Interim order passed a day to continue till the next date of listing.
Oblige, your lord.
May it please your lordship, with the consent of the other party, I beg to mention item number 23 with 24, your lordship, for adjournment.
23 and 24.
Yes, lordship. May I adjourn
Sorry,
to-
why do you mention a matter of 2016?
Your lordship, actually, Mr. M. Chaudhary is supposed to appear, your lordship. He's out of station, your lordship.
What about the other council? 16 matter, sorry, we are not adjourning. Yes,
Maybe Lordship, I beg to mention item number 39. My senior Mr. B. Sinha is out of station due to medical illness.
39. Okay.
Matter may be adjourned for the day, Lord.
We'll have it after a week. Yes,
Sir,
CGC, anyone? K. Gogoi, CGC. Madam, 39. On a prayer made on behalf of the petitioner, at least after a week. 39, okay.
May it please your lordship, this information to the other side, I beg to mention item 5 of today's list.
Hmm.
The government was directed to file its counter. So
Hmm.
the counter is ready. A couple of days it will make, I'll get the offer.
Friday?
Lordship, day after Lordship.
Can you file it tomorrow, day after? We'll have it on Friday.
Friday, subject to the convenience of.
Motion
the
matter.
court.
Let them file it.
Deeply obliged.
MS S. Sharma, Learned State Council submits that the counter affidavit is ready and will be filed shortly, full stop, para. In the interest of justice, list. Oh no, it doesn't. See accordingly, please, for some time. Full stop, para. In the interest of justice, list on 15-3
Deeply obliged.
for motion.
May I please your lordship, consider out beg to mention item number 30, ma'am.
1-3,
30, ma'am.
3-0.
Hello, in this matter, I'll pay for 2 weeks time for filing of a rejoinder activity.
Revenue Department informed?
Yes, my lord, concern.
Revenue. Item 30, on a prayer made on behalf of the petitioner, list after 2 weeks to enable filing of rejoinder affidavit. Is there any
No, my lord, no,
interim order?
no, my lord.
No.
Okay.
Keep your placement.
Yes.
May you please, your lordship, I beg to mention item 20 and 21. 20 was just mentioned today by respondent number 5, but 21 is also similar matter and similar orders may be passed.
21, is Mr. Andeka appearing?
No.
Then,
The subject matter of the cases are same and it may be taken up on Wednesday.
Perhaps it is when full my lord relating to excise tax.
we do not know. Oh, let it come. See, 20, we have a personal difficulty. We cannot take up 20 because of a council. 21, there is no difficulty. We'll have it.
Created a matter.
Item number?
After some.
Outer number? Yes, what?
The learned advocate, he's on deck court.
What is the matter, Mr.?
Regarding on the Panchayat elected body, they have not been allowed to function. So we are praying to allow them till new bodies come. That is the basic.
Okay, after a while.
Also, for the last occasion, the inspection was sought for your daughter.
Received instructions for it. He's not in possession. The instructions read as he's not in possession. And there's a criminal revision application before this honorable court for which the records have been sent. There's a dispute in respect of that matter, Ballot. And the records have been sent in the criminal revision petition awaiting disposal before this honorable court. Once that is received, Ballot,
We issue a short notice, you file the
Yes.
affidavit.
Notice, ma'am.
Sri D. Bora, learned counsel for the petitioner. Full stop. The petitioner claims to be the owner in possession of a plot of land measuring 3 bighas, 3 kathas, 7 lechas covered by xylem, DAG number 413, KP Patta number 90, situated at Revenue Village, Banka Kata, under Choigao Muza, Choigao Pantan, in the district of Kamrup. Full stop. His grievance is in action on an application filed for demarcation of land. Full stop, para. This court, on the last occasion, by the order dated 21/2/2024, had directed the learned counsel for the respondents to obtain instructions. Full stop. Ms. S. Sharma, the learned state counsel, has submitted that written instructions have been received, as per which the petitioner is not in possession. Full stop. Para. The maintainability of this writ petition for the subject matter involved in view of the alternative remedy is also a question which would arise. Full stop, para. Be that as it may, that notice be issued, returnable by 4 weeks. Ms. N. Bordeler, the learned standing counsel, Revenue Department accepts notice on behalf of respondent 1,
2, 3, and 4, Ballot.
whereas Ms. S. Sharma, learned state counsel, for respondent numbers 2, 3, and 4. Para, let extra copies of the writ petition be served upon them during the course of the day. Let affidavit in opposition be filed based on the instructions received.
I have not received instructions. We've written to them, Ballot. Time may be granted sometime.
We issue notice here.
Sure.
Your name arrive here.
M.H. Shoikia,
M.H. Shoikia, Heard Sri M.H. Shoikia, learned counsel for the petitioner. Full stop. The grievance of the petitioner, who is a senior citizen is with regard to the inaction in completion of the process for sale of a plot of land which has been claimed to be owned by her. Full stop. Let notice be issued, returnable by 4 weeks. Miss Anne Bodler, learned standing council revenue for accepts notice of eligible for one.
2, 3, and 4, my lord.
S. Sharma, State Council 2, 3, 4, extra copies during the course of the day. Steps for service of notice upon the respond numbers 5 and 6 be taken by registered post to TD. Steps within 2 days.
May I please, my lord?
Yes.
My lord, the order passed by a learned arbitral tribunal is under challenge, my lord. During this case, my lord, initially, my lord, a demand for arbitration was made, my lord, page 30. Page 30 is the letter by which demand for arbitration was raised. My lord, will see the subject demand for arbitration under clause 64.1 of the agreement. My lord, thereafter, my lord, at page 38, next to 6, my lord, we have replied. The railway has replied, my lord, quoting clause 47, my lord, stating that the claim amount is more than 20% of the contract value, and therefore, as per the contract clause number 47, the dispute is not arbitrable, and they were asked to reduce the claim below 20%. Well, thereafter, they preferred a application under section 11. And my lord, under section 11, they have preferred an application for appointment of an arbitrator. My lord, page 75 is the relevant portion and of the order passed under section 11. My lord, the learned
Page 75.
75, my lord.
Yes.
My lord, thereafter, the learned and the section 11 court, my lord, is directed to decide on the, my lord, will see the last paragraph. Accordingly, this court proceeds to appoint Honorable Mr. Justice Seema Hazarika, retired Judge High Court, to act as sole arbitrator to decide the disputes, including issue of arbitrability. So therefore, my lord, the issue of arbitrability was left to be decided by the Honorable Tribunal. Now, my lord, the Honorable Tribunal has decided the issue of the arbitrability. My lord, proceeding ahead with the arbitration. My lord, the on one hand, my lord, at page my lord, I will. Page 118, my lord, will see. Page 118.
Yes.
My lord, the tribunal has quoted the relevant relevant arbitration clause. And my lord, page 132. From paragraph 16 onwards, my lord, the arbitrator has decided the
132.
132.
Yes.
I have carefully perused the pleadings exchanged by the rival parties, including the written arguments, and heard the arguments advanced by both the parties. Essentially, this dispute regarding arbitrability turns on whether the claimant has a right to invoke clause 64.1 of the GCC.
Yes.
Failing which, when a claimant has a right to invoke clause 48 and 49. So, my lord, here, my lord, page 134, you know, we'll see the last 3 lines of the paragraph.
Arbitration and Conciliation.
Page 134.
Arbitration and Conciliation Act 1996.
Yes. My lord, in page
How have
134.
you come to the writ court?
My lord, because under the act, my lord, there is no remedy, my lord. Since the
You cannot take up this in an application under 34 after passing of the award.
no, my lord, because the decision on the arbitrability has bearing on the arbitral fee also. And apparently, my lord, the contract agreement, the clause prima facie, my lord, bars the arbitrability, stating that more than 20%.
Our writ court.
My lord, it can come,
You
my lord.
filed a suit.
My lord, I'm relying on the decision of the Supreme Court, my lord. Sir, my lord, the judgment of the Supreme Court, my lord, I have given, my lord, in Bhaven Construction versus Executive Engineer 2022, 1 SCC 75, paragraph 11, my lord, this issue came up before the Honorable Apex Court. Paragraph 11.
Yes, paragraph.
Having heard both the
11.
parties and perusing the materials available on the record, the question which needs to be answered is whether the arbitral process could be interfered with under Article 226, 227 of the Constitution, and under what circumstances. My lord, thereafter, my lord, we'll see paragraph 18. Paragraph 18, my lord. It is therefore prudent, my lord, please see the last paragraph. It is therefore prudent for a judge not to exercise discretion to allow judicial interference beyond the procedure established under the enactment. My lord, I'm reading paragraph 18, my lord.
Yes.
Last paragraph. This power needs to be exercised in exceptional rarity wherein one party is left remediless under this statute. My lord, here we are remediless, my lord. Here we have not approached under section 16, my lord. Had we approached
Why,
under-
why remediless? Can't you take up this in the after passing of the award, if at all the award goes against you?
My lord, but prima facie, my lord, the dispute is not arbitrable.
That is one of the, that can be one of the.
And my lord, I am relying on the judgment of our decision of this court, my lord, where on the issue of arbitrability, my lord, the claim was rejected. High Court wrote, my lord, this arbitration petition 34 of 23. My lord, here the section 11 petition was dismissed, and the parties were not agreeing to reduce the claim below 20%. My lord,
So-
this way it will be a precedent, my lord, because
The High Court case is under what provision of law?
my lord,
It was under what provision of law?
it was under 11.6, my lord. That was in 11.6, my
We
lord.
are on the issue of maintainability of our petition.
My lord, there the 20% interpretation was upheld by the, my lord, the court, and my lord,
The court exercising what jurisdiction?
the judgment which I have put, that was under 11.6, my lord.
11.6.
My lord.
That's a different jurisdiction.
My lord, here,
Show us something that even in a 226 or 227 proceeding is maintainable in case you raise the point whether a dispute is arbitrable or not.
because, my lord, this matter was referred by section 11 court to decide on the arbitrability. My lord, we filed objection
So
there.
we are asking again, what
Well,
is your bar in taking up this issue in a 34 application if at
Bar
all
is-
the award
my
goes
lord, bar
against
is
you?
that, my lord, the railway has to pay arbitral fee, my lord, on a claim amount which is prima facie not arbitrable. Because, my lord,
On the question of fee, want to go court to exercise
we also, and my lord,
prerogative jurisdiction for
Well-
the railways, not even a private party.
my lord, the clause prima
Is fee
facie,
your primary ground?
my lord, the contract agreement, my lord, prima facie was the
Mr.
arbitration.
Gupta, we are sorry, but this is not maintainable. And this is not a question of being remediless. Will
No,
your
because
cause of,
the tribunal, my lord,
if at all any cause of action has arisen,
My lord,
will it get extinguished? Never. The award is yet to be passed.
because, my lord, the claim amount more than 20% is prima facie, it is, the contractual agreement bars the same, my
We
lord.
are not going into those aspects.
And the arbitral fee has to be paid on that amount, my lord. That is the problem, my lord. If the parties reduce the claim below 20%, my lord, then there is no dispute at all. And the arbitration can go on. And my lord, this court has already held, my lord, our court has already upheld that 20% same clause, my lord, has been upheld by the court, making the dispute to be not arbitrable. Because, my lord, the tribunal also held it to be not arbitrable. On the other hand, my lord, the tribunal is interpreting on a arbitration on a different clause, my lord. There cannot be two arbitration clauses in an agreement. My lord, the relevant portion which I have just now read, my lord, the tribunal holds the claim to be does not have a right to demand. My lord, will see page 134, that paragraph, last line which I have read. And on the other hand, my lord, the learned tribunal is going into a different clause. There cannot be two arbitration clause in a single agreement, my lord. Page 134, last three lines, my lord, the tribunal is upholding that the claimant does not have a right to invoke 64(1) in view of the 20% bar.
Serious doubts on the maintainability. We'll do one thing.
And my lord, on the other hand, my lord,
Heard Sri H. Gupta, learned counsel for the petitioners who has filed this petition under Article 226/227 of the Constitution of India against an order dated 11/11/2023 passed by the learned arbitral tribunal in arbitration proceeding number AH naam to de diba, page 2 AH 2/2022 arising out of so and so, and arbitration proceeding number so and so, full stop. It is contended that while appointing the learned arbitrator by this court, while a judgment dated 18/11/2022 in RP 20 of 2021, the issue whether the dispute was arbitrable was directed to be considered and decided first. Full stop. Para. Prima facie, the issue of maintainability of this writ petition. No, prima facie, this court is of the view that our writ petition challenging such an order may not come within the ambit and jurisdiction of a writ court, which exercise prerogative discretion. Para, be that as it may, let notice be issued, returnable on returnable on 10th of April. Full stop. Let steps be taken for service of notice upon the respondent by registered post with AD. Steps within 2 days. Para. The issue of maintainability of this writ petition, however, is kept open. Okay. Okay. Yes, Mr. Hazarika.
Petitioners are agree for not properly demarcating their patta length in acquisition for the national highway.
File your affidavit.
Lordship, notice is yet to be issued.
We'll issue notice that
Check the land plans and other details of the notification issued by the Secretary of Mods.
Yes,
Before.
we have appeared before the Deputy Commissioner on 7th, but till now that land details are not.
If not, that it be provided, the state clause is there. If
Yes.
the ignorance is there, because they are then protected. They are apprehension that
No.
they may acquire the land during this adversary.
No.
It is to address the clause. We can go and verify the land of that.
let us issue notice. Let us record the basic submissions and heard Sri P. Hazarika, learned counsel for the petitioners. Full stop. It is the case of the petitioners that their patta lands, which are adjacent to the proposed national highway project, namely so and so Pura Diriba, are likely to be affected. Or have you said affected?
Yes,
Likely to be affected.
are likely to be affected without following the due process of law.
Well.
Para? While this matter was considered on 1/3/2024, instructions were directed to be taken, and the petitioners were also directed to make inspection from the concerned office, full stop para. Sri C. Barua, Learned Standing Council, NHAI, however, submits
But
Uh,
that is
as-
requested by the NHI.
Yes, I am also part.
but this is your submission.
Yeah, of course.
Same submission,
No.
Lord.
Upon-
NHI and NHI.
Sri C. Barua, Learned Standing Council, NHAI, as well as Sri R.K. Talukdar, Learned Standing Council, and HIDCL have, however, submitted that the land of the petitioners are outside the acquisition proceeding,
Argument.
outside the purview of
Yeah.
the notification for acquisition. Full stop para. Be that as it may, let notice be issued, returnable by 4 weeks. Union of India. Your name? MSP Surrogate Learned Council, appearing on instruction of 3 SK Methi, Learned CDC, except for respondent number 1, except to support huh? N. Bodler, Standing Council Revenue for 2, R.K.
for three
Talukdar, and the C. Barua, Standing Council NHAI for 3, R.K. Talukdar,
For 4
Standing Council NHI DCL for 4, Ms. S. Sharma, State Council for respondables, 5 TO2 7. That extra copies of the writ petition be served upon the Learned Council for the respondents within 2 days. Yes.
Item 9 may also be taken up with item 1. First,
Connect-
similar matter.
Connected.
Identical issue, my lord. 1 and 2.
First to item 12 is
12 also.
Here, in this case, the restaurant of 9 and 10 operating a brewing industry without taking permission from the authority, number 1. With the local people, we have the land, landed property, residential house, more school is there within the 500 meter of that area. He operating the brewing industry. We lost complaint to the deputy commissioner, SP, as well as circle officer, but no action has been taken. Now we filed an application under RTI Act, page 35 below.
3-5.
They informed that no permission has been granted. But that's if it ever is going on, no action has been taken.
Yes, madam.
And take a step for disturbing the following of the in the meantime.
Korea Moser. ইটা ভাটা বর্তমানে কোনো অনুমতি পাওয়া দেখা না যায়।
The allegation is as regard functioning of the big industry, but they haven't approached us before coming to the court. At least we could have gone with the right information whether permission has been granted to the big industry. Because these are the right to information says that no such industry is operating. So maybe
Operating now, permission has been.
permission is.
It should be the deputy commissioner. Finally, deputy commissioner is the person who is the granted license. License not granted. They have given no objection. We come to learn. But deputy commissioner not given license because
Well,
that-
why haven't you filed a PIL? You could have
these-
filed a PIL.
It has all the integrated.
because we are our personal right also affected. We are the
That is
we have
okay.
the land.
In we would have been very slightly strict on the PIL issue, but this reply which he has got from RTI Prima facie shows that the precondition has not been met, no permission.
It has been granted.
Take instructions. We'll issue a short notice.
The notice not issued,
Can you serve dusty upon the respondent was said?
cannot make.
Why? Same village.
9 and 10 I cannot.
Why? Same village.
We will be in the, we cannot.
Why? You are how many?
There will be, yeah, also there is some cases are going on in between them, between the public and that respondent number mail. The
How-
police cases are also going.
How many petitioners are there?
Here 4 petitioners come. But
Six
lots of-
petitioners.
6 petitioners, but
Only
lots of petitioners lost complaint to the entire villagers lost complaint to the. DP
Six
reports.
of you cannot serve a dusty on the two
Because
persons.
6 person dangerous, we cannot.
Dangerous. More dangerous than
More
you.
dangerous.
You are admitting
They
you are
will
also,
assault us. I know.
you are admitting you are also dangerous. Who is more dangerous?
Without taking any permission, they are operating the license, Greek industry mill.
And you,
Then- And
you
we
have-
are,
you-
we
and
the
you have the
public,
courage, you have the courage to approach the court against such dangerous person. Then who is more dangerous?
I will try, but cannot. mill.
You try because
I will serve with OC mill. That may be. With police officer, I will. serve mill.
no, that will not do. Then you will give a different image. I've got the OC with me. That liberty we are not going to give you.
Then I will distribute as well as usual person, I will serve.
No, Dusty will give you the liberty if
Yes,
you
mill. Just also, I will.
heard Sri J. Ahmed Learned Council for the petitioners, full stop para. The petitioners who are 6 in numbers are aggrieved by the setting up and operation of a brick kiln by the respondent numbers 9 and 10 at Mayong
Mayong.
in the district of Morigaon. Full stop. It is the specific case of the petitioners that such operation has been done, is being done without taking the necessary permission. Full stop.
From
Sri
the
Ahmed
deputy
has also referred to a document, a communication dated 19/1/2024, which is a response in an RTI application to prima facie demonstrate and substantiate his allegation. Full stop para. That notice be issued. Returnable returnable on 8th of April. Revenue Department and Bodloy, Revenue 1, District Commissioner
23528.
H. Sharma, Learned Additional Senior Advocate Assam for 2, 3, 5, Tier 28, as Barwa, Standing Council Pollution Control Board for 4.
4.
Let extra copies be served upon by tomorrow. Or within 2 days. Let steps be taken for service of notice upon the respondent was 9 and 10 by registered post with AD. Steps within 3 days. Within 2 days. Liberty is also granted to the petitioner to serve the said respondent was 9 and 10 by Dusty, which however is to be required to be routed through the registry of this court. Full stop. The notice accompanying the Dusty is to clearly reflect the next date fixed, that is i.e. 8/4/2024. Before prior to the next date, the petitioners are also required to file an affidavit in support of in proof of such Dusty service.
Name of big industry is MIA brick industry. That may be.
We said 3, 8 and 9.
MIA brick industry.
Brick industry was set up in the name and style.
MAI brick industry.
Message MEI,
Porkarani, Kagulmari, that district.
MEI brick industry. Nalagarh. No,
MAI.
May it please your lord.
item number?
11, lord.
Yes.
This matter it is to acquisition compensation in respect of Assam under Assam Mala project, lordship. My lordship, the department has purchased, negotiated purchase policy, lordship,
Hmm.
from the landowners, lordship. In this regard, they have issued a notice that is annexed 2, lord.
Hmm.
Kindly have a look, lordship, page 16.
Hmm.
May I read, lordship?
Has it been acquired?
It has been fixed in a certain amount, lordship, but I have raised objection, lordship.
No, has it been acquired or not?
It yet to be acquired, but
Then-
my name has been appeared in the list, lord. That is, I have
But what
annexed,
has any cause of action arisen?
annexer 1 document, lordship. The land has been reflected in the list, lordship, to be acquired, lord. And my lord, they have already initiated process for negotiation to purchase those land.
So what is your grievance now?
I have submitted, I have raised certain objections regarding my fixation of land, which was fixed at 26 lakh, lordship. And lord, according to this notice, lordship, if I have raised certain objections, it should be raised before the lordship land purchase committee, lord, but that has not been done. My limited prayer is that, my lord, that matter may be placed before the district level
You
purchase
take
committee.
instructions.
Lord.
We don't think notice should be issued
Yes.
here. Okay.
Not-
Heard Sri R. Fukan, learned counsel for the petitioners, full stop. The grievance of the petitioners is with regard to acquisition / purchase of land under the Assam Mala project. Full
from
stop.
Malap.
It is submitted that the names of the petitioners figure in the list,
The father of the
that the names of the name of the father, both are brothers,
brothers, lord.
that the name of the father of the two petitioners who are brothers figure in the list, and as per procedure laid down, objections can be raised with regard to the price fixed, full stop. It is the case of the petitioners that in spite of such objections being raised, the same has not been placed before the purchase committee,
District level land.
district
purchase-
level land purchase committee. Full stop, para. Let instructions be obtained by Sri H. Sharma, the learned additional senior government advocate. For both the respondents, as well as by Ms. S. Sharma, learned standing counsel, Public Works Department. List this matter for motion on, can we have it on 22nd? Is it okay?
I will try, Lord.
Or 27th? I think 22nd is okay.
Lord, on 22nd.
Para, let extra copies of the petition be served upon the learned state council, learned council for the respondents to enable them to seek instructions.
Obliged.
1/4. Yes.
May it please your lordship. Well, it's really unfortunate that after 17 years of passing of the Senior Citizens Act, the Assam is yet to have that tribunal. And my lord, this is a person, my lord, who was, since there is no tribunal in Assam, so he has filed this petition for constitution of the tribunal as well as seeking the other relief which is entitled under the act. So at this stage, my lord, your lordship may issue notice.
Yes, Mr. Sharma.
Lordship, the prayers which are making by the petitioners, Lordship, all falls under that Senior Citizens Act, Lordship, 2007. Whether it is still constituted or not, Lordship, that
No, it is not constituted. We have gone to the office and inquired.
Let the notice go at this stage, Lordship.
You
Otherwise,
take,
it's a-
you take instructions.
Lord.
Let him take instructions.
Lord.
Third, Sri B.D. Kaur, learned senior counsel for the petitioner. Full stop. The grievance of the petitioner is with regard to non-constitution of maintenance tribunals and which is under the Maintenance of Welfare of Parents and Senior Citizens Act, 2007. Full stop. There has been specific averment regarding ill treatment of the petitioner by the respondents 4 and 5, who are said to be his son and daughter-in-law. Full stop. Para. Let instructions be obtained by Sri H. Sharma Leonard, additional senior government advocate at this stage. Full stop. Let an extra copy be served upon him during the course of the day. Para, list on.
27.
Okay, 27.
Item 1 to 3 and 44.
Yeah.
Which one we have to take first? Mr. Saikia? Which item should we take first?
I would like to 762 of 2024.
7,
760
item number
WP. That will be item number
2, item number 2. Item number 2.
In this case, we have filed a preliminary objection, sir.
Okay, that will be better. 762, who is for 762? Joina Bibi.
Join up with it, but if I'm on behalf of Samuel.
Join up, baby.
Where is Mr. Mandar? Mr. Padgiri, you are in which matter?
Item number 3, madam.
You can start with the issue is same.
It's same, but they have improved the subsequent petition. In any case,
Let us understand the issue then. Till Mr. Mondal comes. Your item is which one?
Item number 3, my lord.
Name?
My lord, Shamsul Haq and 4 others.
Okay.
Let's first argue item number 1, my lord.
I'm calling.
No, but whoever is there, you start. Let us understand the issue. We cannot
Let it
wait
come
for.
tomorrow, Lord, in that case.
Hmm?
If it is not inconvenient, Lord.
Question of court's competence is not there. We are here every day. But let's understand the issue. We can have tomorrow. What is the issue?
Issue is regarding their 5 years tenure of Gaon Panchayat is over. They want extension till the election is. Lordship has decided this case in case of municipal corporation. Because the word is very clear in Article 243, 5 years and no more, no longer. So whether
I think one case, some Fukan. What was the name?
yes,
Fukan.
that judgment.
Fukan something.
Surya Pukan's case.
Two cases were there.
Yes, Lordship. Surya Pukan, 2026 GLT, page 767.
Regarding Shivsagar or something.
Yes, Lord. This is regarding the municipal code.
Yes.
Here it is Gaon Panchayat, but the wordings are same in the constitution.
243,
Have you gone through this Fukan case?
my lord.
How do you overcome this? Because the mandate we have, I think we have held that the mandate of the people comes to an end. It is not a matter of right. Your right is directly connected with the mandate of the people. They
My lord.
selected you for 5 years. 5 years is over. And you cannot claim as a matter of right that you have to continue or be allowed to continue.
Another mandate is that, my lord, prior to it, completion of the term, my lord, the state respondent have to hold election, my lord.
No,
Before-
that
that
we
is
have,
the
we have,
another
we have
mandate, my
handled,
lord.
we have dealt with that submission. For some purpose, if selections are not held, can you, as a matter of right, say that, no, we have to be allowed to continue? I don't think so.
And I have annexed, my lord, in the, my lord, Dibrugarh Jila Parishad, my lord. This honorable court, my lord, directed the respondent to hold the election within the specific time, my lord.
Now,
And in
suppose
the,
in a given case, there is some eventuality for which the elections could not be. See, holding of elections is a mandate of law,
my lord,
but there may be some circumstances for which holding of elections, suppose for COVID, it was not possible. So what will happen? Will you get an automatic extension?
I have another argument, my lord, that my lord, near about 2 years, my lord, I have not functioned, my lord, due to COVID-19, my lord.
Those are different matters. How do you? That cannot be linked with this.
Could made, my lord,
And
direct
these
to
matters are settled already. We thought something else was there. Mr. Mondal. What are the articles involved?
Now, my lord, item number 9, my lord. Yes,
What are the
And-
articles involved?
my lord, sector, article, my lord, 243E.
Constitution of India. Constitution of India. Get it. Mr. Mohanta?
My lord, my senior will, my lord, will endorse.
my lord, for interim protection today, my lord. So already, my lord, in similar line, my lord, your lordship kindly see this honorable court has passed an order.
Which case?
In earlier, my lord, that I have one order, I have annexed, my lord. Your lordship kindly see. Yes, 220.
Now we are hearing the matter finally.
Then, my lord, we have already filed an application, my lord, Miss case for IF for impede the respondent number 6, my
Who is 6?
State Election Commission.
That will decide. If there's any requirement, we'll decide. You have to tell us what is the mandate of law?
Mandate of-
The people have elected you for 5 years.
Yes, absolutely correct.
5 years is over.
Absolutely correct.
Where is the right?
Your lordship kindly see, right? Yes. One, they are right, they have not exercised their right. Your lordship kindly see 243, my lord, 243E. Your lordship kindly see, my lord. They have to hold the election prior to that, my lord. Normally, a elected body hand over the, my lord, charge to elected body.
Now, suppose the election is not being held in time. What
My
will be the
lord,
consequence?
My lord, then, my lord, that body will normally, my lord, that body will continue, my lord.
Till
but
how
without-
many years?
Man, now, my lord, without election, how many years, my lord?
You tell us.
No,
You have to tell
suppose-
us. You have to tell
No,
us.
for their fault, why, my lord, that elected body will suffer?
Where
suppose-
are you
no.
suffering?
Your lordship kindly see.
Where you have to show your suffering that prior to your term you have been
No,
ousted.
exactly, we are elected
You have
for 5
completed.
years.
You have
My-
completed your
I
term.
agree.
For their election.
No, I agree. No,
Yeah.
if they say that tomorrow we will hold the election, but day after tomorrow, after 2 weeks, I will hold the election, then all right. But your lordship, can it be kept for indefinite period?
That's a different issue altogether. That issue,
No, my lord, that issue has linked, my lord.
that issue is not
No,
for us.
suppose, yes, as per,
Timely elections is a mandate of law. They have
exactly,
to-
my lord.
But there may be a condition or some eventuality where the elections could not be held in time, cannot be held in time. Will it give you a right to continue after 5 years? Yeah.
No, my lord, suppose, my lord, that is constitutional obligation to form a part of the state machinery, my lord. That is also not been done. So, my lord, that is the
how-
reason, my lord, this honorable court, my lord, earlier, my lord, that his body will continue, but without any major decision. That is the normally, my lord,
How will you overcome Surya Fukan?
my lord.
Surya
That-
Fukan.
That,
We have decided this issue long time back.
no, long, there is another judgment of the our High Court also, my lord.
Please tell us.
That place, my lord,
to us.
no, demand rakhna, area dilo.
That judgment is against you.
One judgment is in favor of them. of
No, that, my
2005.
lord,
Hemaji.
Uttor Hemaji,
Yes, let us see.
Uttor Hemaji.
Petition.
Uttor Hemaji, my lord.
Citation.
In fact, that
It's a part of the petition.
part of the petition, in my petition, my lord, that is the impugned order, my lord, interim order. In that case, my lord, interim order is granted. Citation, my lord, 2007 TZLT 899.
Which is your matter? Which is your matter?
In my matter, now my matter is, my lord, WPC 844
844.
24 844.
Noor Nehar.
No Nehar, my lord.
Page.
Page, my lord, your lordship will find page 36, my lord.
36.
36, my lord.
Yes.
And 11 portion is, my lord, 37.
No, this is an interim
My lord,
order.
that is ultimately, my lord, the final decision has been taken. That is 2007.
Where?
No, this order is based on an earlier order. Your lordship kindly
So
see,
was the law which has been laid down.
my lord. Page 37, all Ali has also produced before us a copy of the order dated 14/3/2018 passed in WPC number 1374/2018. Peruse the aforesaid order dated 1/4/38. In view of the actual background is considered appropriate notice in the Senate. Notice is so and so. No formal step is regard to the respondents are called for so and so. Following the said order provided and as an interim measure that the petitioner Gram Panchayat whose term is expired on 23/3/2018 shall be allowed to function till the constitution of new Gram Panchayat. However, the petitioner Gram Panchayat are restrained from taking any policy decision, injury and expenditure of the fund otherwise mentioned to.
Yes, this is an interim order.
That is interim order. That your lordship kindly see 2007 TZLT
Yes, please.
899.
Please, do you have a copy?
Yes, my lord.
2007.
That is the final order.
2007. 3.
TZLT 899.
Name.
Name, my lord, Uttor Hemaji Gaon Panchayat and others versus State of Assam. And various writ petition filed at that point of time, my lord.
Paragraph.
Paragraph, my lord. Paragraph 14, my lord. 14D.
1/4.
1/4. 14D, my lord. Subclause D. Subpara D, my lord.
14.
My lord.
14D. Uttar Hemaji.
Uttor Hemaji.
There is no 14D.
In fact, my lord, 14 is the last paragraph.
No, here Uttar Hemaji judgment dated 25/5.
Judgment dated, my lord.
25/5.
Yes, 25/5/2007.
Okay, okay. Yes, yes, yes. Yes, yes, you're correct. You're correct. 14D. D. Yes, please.
Go back. Go back.
14D.
Yes, madam. The Gaon Panchayat, Anchalik Panchayat and Jila Parishad whose terms had expired because of the failure on the part of the state respondent and state election commission fulfill mandate of the Gaon constitution whole election before the expiry of the term shall allowed to function till the constitution of the new Gaon Panchayat, Anchalik Panchayat, Jila Parishad after completion of the election, but they are not allowed to take any major policy decision, make any expenditure from the fund other than the payment of salaries and staff and property. So all the election of the Gaon Panchayat and Panchayat and Jila Parishad shall be completed within so for the completion with the indirect election constitution. that the impugn notice dated 20th accordingly, the impugn notification was and status. My lord, another, so that was the mandate of the 2007 judgment, my lord.
Okay.
So another point, my lord, you will also kindly see the notice, that impugn order, my lord. Kindly see, my lord, impugn order, my lord. Page 23, my lord.
23.
Page 23. The governor of Assam pleased to allow the concerned district commissioner or authorized official of the custodian of the property of the Gaon Panchayat, Anchalik Panchayat, Jila Parishad, gap period, that is after completion of the terms until the completion of the election process, as election cannot be held within the specific permissible time limit. This issued in pursuant to Section 7, Section 35, Section 68, and Section 125(4) B of the Assam Panchayat Act. Section 7 is applicable to me because, my lord, that is Gaon Panchayat. So, but others are Jila Parishad and, my lord, that is not applicable. Now, your lordship kindly see 124, 125 subclause 4 of the Panchayat Act.
One.
125
Panchayat called down. It is.
subclause 4, my lord. So 125 is a dissolution of Panchayat. If the opinion of the government of Gaon Panchayat, Anchalik Panchayat, and Jila Parishad.
But iman ডাঙৰ নহয়। নহয়, কিতাপবিলাক চুই থাকিবলৈ জানিব লাগে কিতাপবিলাক।
My lord, I have 2 books, my lord.
কিতাপবিলাক কিয় নাজানো?
That is new book, my lord.
এনেকুৱা বেলেগ নহয়, অসমৰ কিতাপ অলপ হাৰ্ড বাউণ্ড এনেকুৱা ধৰণৰ হয়। আছাম ফিচাৰী ইনভেষ্টমেণ্ট।
Page 126. নতুন কিতাপ দেখুন হৈ যাক 126 হয়।
আমাৰ কিতাপ কি হ'ল? এইখন কিয় ল'ব লাগে? মই বিচাৰিছো নেকি এইখন? আমাৰ কিতাপ কি হ'ল? এইখন কি? এইখন কি তলৰখন? কিয় কিতাপ নাপায় বিচাৰি? ডিউটি নকৰে যদি নকৰিব। সন্মুখত কিতাপ আছে বিচাৰি নাপায়। এডভোকেটৰ পৰা কিতাপ ল'ব লগা। এইখন কিয় বিচাৰি নাপায়? সন্মুখত আছে। Yes, which page?
126, my lord. Page 126, section 125.
Section 125 of the Act.
My
Of the
lord.
Act.
Panchayat, yes, ma'am. 1990.
One, 2, 5. Dissolution. Dissolution.
Yes, dissolution of the Panchayat. Yes. If the opinion of the Gaon Panchayat, my lord, Anchalik Panchayat, Jila Parishad exceed or abuse of power, or it not competent to perform the make persistent default in the performance of the duties imposed under this act or other law timing post, the government may, by an order publishing official gazette, dissolve the Gaon Panchayat, Anchalik Panchayat, Jila Parishad, and maybe before publishing an order, the government shall communicate to the Gaon Panchayat and the Anchalik Panchayat Parishad of the to fix the responsible period of Panchayat. When Gaon Panchayat or Anchalik Panchayat or Jila Parishad is dissolved, all these members of the Gaon Panchayat of the Anchalik Panchayat or Jila Parishad shall, from the date of in the order, vacate the office of the first member. The Gaon Panchayat or Anchalik Panchayat or Jila Parishad is dissolved. My lord, is dissolved by exercising this power, my lord, when, my lord, for their fault of the Panchayat, my lord, prior to that it has been dissolved, then only, my lord, that property has been taken away, my lord. But that section is not applicable to, my lord, the normal tenure, my lord, when computed in normal tenure, my lord. So now, my lord, by exercising that 21-25-4, my lord, they have taken away the property, my lord. Everything has been custody and, my lord, one man, one, my lord. Probably that is, in our case, video is, my lord, in case of Gaon Panchayat. Yes, my lord, video has been given power, my lord. So if your lordship, my lord, here entire matter that is fiction, my lord, is Thursday, my lord.
No, you're reading today.
My lord.
We are hearing now.
No, that, my lord, implead petition, my lord, ultimately, my lord.
Impleadment will take a call. If we think that impleadment is necessary, we have told you before. What role has the election commission to do
No, that
with
is,
your resolution? It's an order agency to hold the elections.
yes, my lord.
So
But
what
election
role
will
is
be
there?
held by, my lord, as per Panchayat Act, my lord.
Will they have any say in this matter?
My lord.
Will they have any say in this matter? Are they necessary parties? We'll not go into the matters. If we think you can make out a case for impleadment, we'll definitely implead. But this is on a different footing altogether. Your tenure has ended. The custody has been taken over by the deputy commissioner, district commissioner, or his authorized representative. You say that you should be allowed to continue till the next election is held.
No, continue, my lord. As per the earlier order of this honorable court, my lord, that's my lord, without taking any major decision, my lord. Otherwise, my lord.
That is without.
So that is our prayer, my lord.
Well, we are considering that. If we have a difficulty today, tomorrow, then at best. But we are completing these matters. Tomorrow?
Tomorrow, my lord.
Okay.
No, I have no difficulty, but only I am preparing only for the. I have seen their today.
You are always prepared, Mr. Mahanta.
He may have some other difficulties. Material.
Materially, no problem.
Those matters will not comment. And seeing who is beside him, we better not
The
comment.
assistant council will be able to inform you.
You are for election commission. We may not be, your presence may not be required. But have some of your colleagues.
No, nothing.
Considering the subject matter involved, comma, this matters. This court is of the opinion that the matter should be finally disposed of, full stop para, as certain difficulties have been expressed by Sri T.J. Mahanta, Senior Counsel for the petitioners, comma, list for consideration tomorrow. All the matters. Please give the other numbers. Item numbers 9, 12. So,
One, some cases were not.
doesn't matter.
Will keep list matter.
কিতাপবিলাক চুই থাকিব না, কিতাপবিলাক কিয় বিচাৰিব লাগে? এইখন কিমান সাইজৰ হয়, কিতাপ দেখিলে গম পাব লাগে।
The petitioner before the Lordship is a Ramuguri Cooperative Society, one of the oldest cooperative society of this state. It is registered on 1957.
Yes.
So what is happening here? The annual general meeting is held. And before general has been there is a requirement of the voter list to be approved by the competent authority as per the act. And Lordship will kindly take to Annex 4, page 35.
35,
Page 35, Annex 4.
yes.
Peruse the board director proceeding 14/8/2020 of Jamuguri Cooperative Marketing Society and Proceedings Society, wherein it has been resolved to hold the annual general meeting election to the board on 26/9/23. Now, the exercise of the power conferred under 41(1) of the Act electoral roll has been prepared by the board of directors, hereby approved and published.
Yes.
And further, the exercise of the power conferred under the rule of the Cooperative Society Rule 19, Assistant Register Cooperative Society being the election authority, hereby appointed and following senior and junior inspector, and thereafter the returning officer and the assistant returning officer is appointed.
Yes.
And thereafter the Bhutan is published, there is no objection for whatever from any part of water. And Annexure 7, page 41, the AGM has been held. AGM has been held and duly elected the directors in presence of the competent authority which are appointed there. And thereafter what is happened, as per provision of the law, the copy of that AGM, the resolution AGM should be sent to the competent authority. Here the assistant registrar of cooperative society, because it is a subdivisional cooperative society.
Okay.
And Rule 45 of the Section 45 of the Act says the provision said that every cooperative society shall record the minutes of the book in official language. Can you take it?
Assam Panchayat Act. Assam Panchayat, no, cooperative. Cooperative. Yes.
45. Maybe in page 41 on this book.
Yes.
Every cooperative society shall record in a minute book in official language in English or any other language prescribed by law, and proceeding of every general meeting delegated by law, and meeting board meeting, and the names of the members of delegate present are and shall be confirmed for the same next meeting. The proceeding of the all general meeting or civil general cooperative society, it shall be sent to the register within 15 days from the date of completion of the such meeting, and the registrar shall give his approval resolution within 15 days of the receipt of the proceeding. If no approval is received within the proceeding shall be deemed to have been approved. Here also will find on the authority, the cooperative society stand on 3/10/23. Give page 51, Lordship.
Yes.
And why they are waiting for the next meeting is required for the selection of president and secretary.
Yes.
And therefore they wait for the formal reply from the official. But there is no any communication come from the register about competent authority. Therefore, it by operation of law, it is deemed to be approved. Now what is happening? Now Lordship will find without any objection. Here also there is no objection of the electoral from any members of the society, and no objection of the general meeting, any members of the present in the society, as per provided in the law that specific time is given. Raise objection. What is happening on page 54? Lordship will find.
Yes.
Without any objection, without the Eastern District Deputy Registrar of Cooperative Society, Lordship will find.
Yes.
Inviting reference, I would like to reference office order number so and so 19/10/23. There is no such order which is given to us. In inviting, I would like to inform you that the preparing the member list under section 26 of the Act, management has not maintained the following provisions. Number one, a management due member of list in manner reconstruct by resolution 10
Mr.
of the
Talukdar?
20.
Hello, in fact, this order may be right or wrong, we don't know. There is a provision for appeal, my lord. Because this order is passed by a departmental officer. And people once say, any order passed by a subordinate officer is appealable to the registrar. There are, my lord, certain facts which are required to be, my lord, ascertained. So therefore.
My submission on that, because this order, I am telling in this order on 54, there is no specific, what he says, he suggested that the assistant registrar. This order, what you find, in view of the suggested to assistant registrar to pass an appropriate order under 41(6). What my is that when a meeting, the resolution of meeting is already deemed to be approved by operation of law, any order.
Now, what is the present stage?
My thing, that I should be get the approval. The order itself is non-existing law.
Now, what is the present stage? What is going on now?
We
Who-
are functioning in it.
They are functioning.
There is no person appointed till
My
then.
lord, in fact, the order at page 54, it says, my
We
lord.
can do one thing.
Well.
For the time being,
Well.
since appeal would go into the facts, we'd give them some protection, file the appeal in a particular time, and dispose of the appeal.
Well, that can be.
Okay.
And even then also, my lord, because this is the consequential order has not been passed yet. That is not, my lord, annexed here.
Now, that is one, there is one 16/2/2024, page 53.
No, my lord, eventually, my lord, 16 subsequent to 16 my lord, there is another order. Yes, this order has been annexed subsequent.
Yes, 16/2 has come first after 3.
Yes, my lord, but this is not the authority who will pass the order under 41(6). That will be passed by the zonal registrar. So yet, my lord, this order is not passed. Authority may say, till 40, my lord, they will file an appeal and till.
Appeal is under which provision?
111.
Table 1, section 2.
Authority will fix the time limit.
Will dispose
it
of
of, my
it.
lord.
Heard Sri P.P. Barua, Learned Counsel, for the petitioner. Also heard Sri S.K. Talukdar, Learned Standing Counsel, Cooperation Department. Para, considering the subject matter involved and as agreed to by the parties, the instant writ petition is disposed of at the motion stage itself, full stop. Para, the petitioner is a registered cooperative society and claims that in a meeting held on 10/5/2023, the list of members of the society were unanimously approved, full stop. Thereafter, the Board of Directors, vide meeting dated 14/8/2023, had resolved to hold the annual general meeting on 26/9/2023, which according to the petitioner was duly held, and the minutes of the proceedings were sent for approval by the competent authority on 3/10/2023. Full stop. However, since there was no response, the approval was deemed to be, the minutes were deemed to be approved, and accordingly, the society has been functioning, full stop. It is the case of the petitioner that they were in receipt of an order dated 16/2/2024 issued by the ARCS Tejpur, whereby it has been informed that the AGM on 26/9/2023 was held by was held with an erroneous members list. Full stop. The petitioners could also petitioner could also obtain a copy of a communication dated 3/2/2024, from which it appears that there were certain inquiry which the petitioner was not aware of. Full stop para. Accordingly, the writ petition has been filed. Full stop para.
But only one aspect to my lord, Major Lord. Since my lord, there is no approval by the my lord department, and election has been held. So my lord, the submission that they are in office, how can it be, my lord?
Sri S.K. Talukdar, learned standing counsel of the department, has however raised an objection that without there being an approval
My lord, under 45, section
of
45.
the minutes of the meeting of the AGM, as claimed, comma, the question of functioning of the cooperative society,
Board of the board.
of the board
Well.
of directors would not arise.
Well.
In any case, comma, he submits that section 111 of the Assam Cooperative Societies Act 2007 provides for an appeal, and the issues raised being consisting of factual disputes can be best raised before the appellate authority. Full stop. Para. No, para no. He accordingly submits that the petitioners may be directed to file an appeal. Full stop. Para. Sri Barua, the learned counsel for the petitioner, submits that though he is not opposed in principle to preferring an appeal under section 111, comma, he submits that some protection may be granted till such disposal of the appeal. Full stop para. After considering the facts and circumstances, comma, the instant writ petition is disposed of by giving liberty, by directing the petitioner to prefer an appeal under section 111 before the appellate authority on or before today is 11th, on or before 20th of March 2024. Full stop. The appellate authority, on receipt of such appeal, may decide and dispose of the appeal expeditiously in any event within a period of 45 days from the date of receipt. Full stop. While doing so, comma, the petitioner and the other stakeholders is to be given an opportunity of hearing. Full stop. It is provided that till such appeal is disposed of, comma, the petitioner would be allowed to function, which should be dependent on the final outcome of the appeal. $16 years.
My please a lot. In here, your lordship.
Yes.
The public had already made some complaint, your lordship, before the authority concerned.
Regarding
running of illegal cluttering, your lordship, in the middle of the town, your lordship. And in response to the state complaint, your lordship, page 25 kindly.
You are part of the public.
Yes. Page 25 and 26, these are the communications.
Yes, you take instructions. Item A.M. Khan. Third 3 A.M. Khan, learned counsel for the petitioners. full stop, the grievance of the petitioners who claims to be local residents of village Bhimapara in the district of South Salmara claims that there is an illegal business of cow slaughtering run by the private respondent against which, oh, he has not been made a
No,
party.
No, he has not been made party, Your Lordship,
Why?
because he is not the lessee, nothing, Your Lordship.
This is not proper. You are making serious allegations without hearing him. How can we? We thought he was a party. Slaughtering by one Safiqul Islam. Respond Nakoba, huh? By one Safiqul Islam. Full stop. This court has, however, noticed that the said Safiqul Islam has not been made a party respondent. Full stop. Para. Petitioner may file appropriate application for implement.
Right.
Mr. Chaudhary, we are waiting for long. Which matter? Motion matter.
Yes,
Second half, this court has a commission, so we'll not be able to sit.
my lord.
Second half, there's the Manipur commission, so.
Yes, yes.
Item number?
43, my lord, eviction man.
Oh, I think we'll,
Yes.
we'll reach.
The government allotted land, my lord, mutated, my lord, in the year 98. But 99, there was one letter issued by the government, my lord. It was, my lord, again, my lord, it has become the first land, my lord. Subsequently, we have submitted representation. And we are, my lord, already in the.
One matter you have moved already.
Lordship?
I think one matter, similar matter. you
Yes,
had
but
moved.
already disposed of. I have annexed here, my lord.
Okay.
Paragraph, my lord, that is, my lord,
We'll issue notice, take instructions.
But in addition to that, your Lordship may kindly come to page 30.
No, therefore we are issuing notice.
No, there are certain mistakes Lordship there.
Okay. Page 36.
Page 30.
Yes.
Annexure 7, page 36.
Yes.
In the middle portion, in the above scheduled plot of land, you are allotted to take position by constructing a house. This is the English translation, next page.
Name not of sale
নিম্ন তফসিল বর্ণিত মাটি আপোনাৰ ঘৰ সাজি ভোগ দখল কৰি থাকিবলৈ সিপিঠিত উল্লেখিত চৰ্তৰ সাপেক্ষে আবণ্টন দিয়া হ'ল. That shorts are not annexed. Apart from that, the translation is wrong.
Even the translation, the second page is not there.
It is something.
Why don't you annex the entire document?
At least certain conditions were imposed upon them for constructing the house.
now only this paper I have. Anyway, but I'll file it.
No, no, this paper, how can it be? See at page 37,
Yes, my lord.
which Mr. Sharma has rightly pointed out. হিপিঠিত উল্লেখিত শর্ত সাপেক্ষে আবণ্টন দিয়া হল.
I'll, my lord, file
Certain
it.
conditions were there, Lordship.
You bring an additional affidavit.
Yes, my lord, I will.
It appears that in one of the annexures, it appears that one of the annexures within bracket annexure 7 is not complete.
Complete.
And even the English translated version is not correct, is apparently not correct. Full stop para. Sri Das, the learned counsel, is at liberty to file additional affidavit to bring the complete document on records. List along with the affidavit. After 2 weeks?
1 week.
After a week.
The petitioners are farmers and traders of 3 species of fishes, my lord. Sanna bleheri, Sanna stewarti, and Sanna orantimaculata. So the forest department, but they are wrestling these fishes with another kind of fishes. That's called Sanna barca fishes. This prohibited fish under Wildlife Protection Act, my lord. So in this case, they have also filed some cases against the, not against the petitioners, but some other farmers and cultivators. So we have also filed one representations before the respondent.
Yes, Mr. Goswami.
Till date, my lord, none of their rights have been infringed. They say some
No,
person.
this, it's only for consideration of the representation.
Difficulty is that, my lord, Well, by giving different name to these protected species, my lord.
No,
They-
you take instructions on the representation. How have you dealt with the representation?
PC will not be the authority because my lord will kindly appreciate one thing.
Who
This is-
will be the authority?
This is a list, my lord, incorporated by the Union of India, my. Union of India is not a party. They, by giving some different name to this species, my lord, which is a
No,
schedule.
that we have understood. From the opening statement, we have understood what is your, but they claim there is a representation. We are not very keen on entertaining this petition at this stage.
My lord.
At the same time, we
Let
do
us
not
file a
want.
representation before the PCCF and HOC.
We have already filed the petition representation before a different
PC is not an authority.
You have to file before the PCCF.
PCCF.
Is PCCF a party?
Because there
Yes,
is-
yes, my lord.
There is not a
PCCF is
Where-
case
where-
registered against the petitioner.
No, case is not registered, but
I think that they might be arrested. There may be cases registered. That's the apprehension, my lord, purely.
there is no clear differentiation between these three species, my lord. And because of this baffling situation, we are also suffering.
Towards redressal of the grievance, the petitioners claim to have submitted representations before the authorities. Full stop. So the P.N. Goswami, Leonard, Standing Counsel, Forest Department, however, submits that such representations were not before the appropriate authority,
PCCF wildlife, man.
namely the PCCF Wildlife. Para. Shri, what is your name?
US Bora.
Shri U.S. Bora, Leonard Counsel for the petitioner. Prays for and is granted 3 weeks' time to submit representation before the appropriate, before the aforesaid authority, namely PCCF Wildlife, and bring the same on record by way of an additional affidavit. Full stop. In case such representation is filed, the same may be considered in accordance with law.
Public.
Yes.
The Lordship, here the petitioner is the owner, possessor of a plot of, actually a plot of land.
Okay.
Now, he purchased the possession of this very plot of land in the year 2009. And since then, he has been possessing that very land. Surprisingly, in the year 2022, government of Assam has allotted patta upon with regard to this land. May Lord kindly see vernacular copy.
To 7 and 9, respond number 7 and 9.
7 to 9, yes. Their name were inserted. Accordingly, we have filed a representation to the deputy commissioner because he is the authority, but our representation has not been considered till today.
What is there on record, or what materials are you relying upon to show that you were in possession?
Oh, my lord, kindly see. Page 15, an unregistered sale deed. Page 15, vernacular is the page 16.
These are not factual disputes. How do we go into this kind of disputes?
My lord, kindly, my representation may be considered, my lord, kindly.
No, representation on the basis of what?
On the basis
You have to establish some basis, some foundation.
that their name were inserted as because they are not the possessor of that very plot of land. We have been possessing that plot of land.
You show us some semblance of right, some materials from which it can be ascertained that you were in possession, at least your claim. What is that material? What is the document?
We have
Your
been also, my lord,
oral statement.
we are paying the revenue also.
Where?
Revenue receipts kindly page 31.
Revenue receipt of which year?
It is 2024 and another is also
2024, February.
another, yes, another also 29, page 29.
29.
2019. 24/5/2019.
But you say
page
that
29.
you say that you are in position since 2009. Show us something, not 9, then 10, then 11. from 19 and 24, this is not enough.
After 19, my lord, there in the year 2022, their name were inserted. Kindly, our representation may be disposed of.
No, no, not like this. This is not a forum to come for representation disposal. Don't come like this. You have to establish some kind of right. We are not going to give the burden to somebody, shift the burden to somebody. We'll take the burden to
Now,
ourselves.
my name is also there, my lord.
Where?
My name is also in Patta.
Where? Patta?
Yes,
Where is the Patta?
page 23.
You said this is Axonia land.
Thereafter, it has become Niyadi Patta.
23. Yes.
Page 24. Ainal Hawk.
Where?
Last number 4. Ainal Hawk. And type copies, page 22. Page 22, serial number 4, Ainal Hawk.
Then what is your problem now?
I am the possessor of that very plot of land, but why their name were inserted on what basis, my lord? That's why I made a complaint to the deputy commissioner and circle officer.
Who is within bracket, who is this Haran Ali
Ranali is the father's names of the Ainal Hawk,
of the petitioner?
of the petitioner.
Yes.
When you silence their representation at page 32,
Page?
Nectar 7, page 32.
32, yes.
District Commissioner, chairman, district level advisory board.
Yes.
So they should, if their name has been inserted, the partial, so they have to file an appeal before the deputy commissioner.
No, we have filed.
This is not an appeal.
Not able, this representation I have filed. My lord,
Against the order of this, that they have to file an appeal,
my lord kindly see. Rule 116, Rule 116,
147 or
under Assam Land
148.
Revenue Regulation 1886.
What is your name?
KTM Hussain.
Letter number? Heard 3 ATM Hussain Learned Counsel for the petitioner. Full stop. It is the case of the petitioner that since the year 2009, he is in possession of a plot of land measuring 7 bighas, 4 katha, 5 lacha, being Axonia, within bracket Axonia, which he claimed to have purchased by an unregistered sale deed. Full stop. In a recent process for conversion of the land, comma, though patta has been issued, comma, along with the name of the petitioner, comma, certain other names have been incorporated, which includes the name of respondent 6.
7, 8, 9.
Oh, who is 6?
It is not. After 5 minutes.
Oh, my lord.
Respondent 6 to 10.
6, 7, 8.
Which
6, 7, 8.
includes respondent 6 to 8, 6 to 10. 6 to 10. Oh, not at 10. 6 to
6.
6, 7, and 8.
8.
6, 7, 8. Full stop. The petitioner also claims to have filed representation. Put the para. Let notice be issued. Returnable by 4 weeks. 3. J. Hendick. No, Chief Secretary. Yes. State Council. State Council.
I'm for respondent 3, 4, and
No,
5.
1.
One
Chief
my-
Secretary.
my-
1, Chief Secretary.
Oh, Chief Secretary, I can.
Okay. Sri J. Hendick Learned State Council accepts notice on behalf of respondent 1.
1, 2, 1, 3, 4, and 5.
1, 3, 4, and 5. Whereas Miss M. Bodloy, Anne Bodloy, Learned Standing Council Revenue Department. Except for response number 2. Let steps for service of notice be taken upon the response number 6, TO2, 10 by registered post with AD. Steps within 3 days. Extra copies to Likiba, State Council. Yes.
May it please your lordship, the counsel for the petitioner as protocol is in some other court, let them
Wednesday.
witness.
On request made on behalf of the petitioner, list for motion on Wednesday.
The covered matter, Lordship.
Covered
Covered matter
under?
is a forest and rural,
Forest?
royalty regarding payment of
Okay.
forest.
Yes, Mr. Bora?
I am for the.
Interim is
but-
covered. That
Interim-
you are making your own, not a, on your own, it's not a government contract.
Yes, Lordship. I'm a private individual.
Over your own plot of land.
Yes, Lordship.
Heard Sri D. Barua, Learned Counsel for the petitioner who is aggrieved by a communication dated 2/3/2023 requiring payment of forest royalty. Full stop. It is the case of the petitioner that the construction in question is a private construction wherein there would be no application of the impure notification. Para, which page?
42, Lord.
No, the earlier order.
Law order, I have not enacted.
It is also informed that in similar matters, interim protection has been granted for Kapara. Let notice be issued, returnable by 4 weeks. 3. R. Google Standing Council Forest Department accepts notice on behalf of respondent 1 and 2. Rest
For response number 3 and 6, my lord.
what about 4 and 5?
4 and 5.
Mines,
Government.
as Bora Standing Council,
Yes.
Housing and
And-
Urban Affairs Department for respondent number 3 and 6.
Yes.
And 4 and 5, Mr.
Government.
Hendik, Mines Department,
Mines.
J. Hendik, State Council, for respondent 4 and 5, extra copies, within 2 days. Para. Heard on the interim prayer, after hearing, it is provided that the concerned authorities would not insist upon payment of forest royalty for the construction in question. Full stop, para. List along with WPC
2040. 2020.
2040 of
2023.
23. Yes.
We have filed a affidavit also, Lordship, and there is a reply to that also.
What is the matter?
My lord, in fact, the petitioner, they are facing, my lord, great hardship, my lord, and difficulty. And having, my lord, identical grievance, my lord, and cause of action, they have joined together. Now, the petitioners, my lord, they are 13 in number. They are, my lord, running business, my lord, in the premise of the ASTC, my lord, at Falcon Bazaar, of restaurant, courier cargo, business of tire, battery, fast food, stationery shop, etc. And they have been, my lord, allotted space, my lord, by the ASTC from 2002, 4, 5 at various, my lord, time,
Okay.
different time. And presently, my lord, they have been almost, my lord, 20 years, my lord, they are running their business. Now, my lord, a decision has been taken, my lord, by the ASTC as well as, my lord, the government. There is a tripartite decision, my lord, to hand over, my lord, that land, premise, my lord, to railway, so that it can be made a second entry point for, my lord, going to railway station. So now, my lord, in that respect, my lord, I have nothing to say. My lord, it's done in public interest, my lord. But, my lord, my humble submission is, at the same time, my lord, my prayer would be, the ASTC is also required, my lord, to balance some equity. Because if your lordship sees the allotment letter, at the, my lord, allocated by the, my lord, railway, some kind of, my lord, tenancy has been, my lord, created. Rent, my lord, monthly rent, my lord, has been taken by the ASTC, my lord. We have been allowed, my lord, to construct permanent structures. I'll come to the allotment letters, my lord. And thereby, my lord, we are running our business as well. So on the last occasion, my lord, when the matter was taken up by the Honorable Court, I made a submission that the provisions of Public Premise, my lord, Act 1971, my lord, apply. And the respondents not having, my lord, followed the provisions, my lord. So therefore, the termination letters, my lord, are, my lord, non-net. But on a deeper examination, I'm sorry, on a deeper examination, my lord, I find that the provisions of the Urban Rent Control Act will also apply. So in that view of the matter, the procedure laid down therein, my lord, will also equally apply. Now, I am not making an extreme argument that the ASTC, my lord, should approach the civil court and thereby obtain a decree, since I am protected by section 5 thereof. My respectful submission before your lordship is, being a constitutional court, your lordship may, my lord, would like to please, my lord, to balance the equity. My submission would be that there are other premises owned by the ASTC, my lord. One at Thanapara, another, my lord, is ISBT, one at, my lord, is Ulubari. And in the present premise also, my lord, there are 2 bighas of land. I have stated a restaurant has already been allowed, my lord, to run therein. So whether or not the STC can, my lord, accommodate us in either of these, my lord, premise, if not together, separately, my lord. So that would amount to balance the equities, my lord.
That is a different area, lordship. Otherwise, legally, we are in a strong footing, lordship. He was originally given the allotment in 2005. Lordship will kindly come to page 38. One of the condition very clearly stated there.
Yes.
11. You have to vacate the said space if it is required by ASTC's own use within 1 month's notice. So this was issued, allotment order was issued in 2005. So this is the condition in the allotment order. And subsequently there is a deed of license, page 63. With some of the persons, this license was also executed, deed of license. Have lordship got it?
Yes.
Clause 7 and clause 10, page 64.
63 starts.
It starts at 63,
64
relevant
clause?
64, 7 and 10. That it is also agreed by both the parties that if in any case the said premise, space, stall, shop is required by the licensor for the purpose of its own use during the period under this deed of
Mr.
license.
Sakya,
Yes.
we can do one thing, since we are in shortage of time. Tomorrow we'll have this.
Day after, let it be there.
The day after will be long, my lord, late, because
It
by
will not be
tomorrow,
late.
tomorrow is the last date. They
No,
say,
it
my
is-
lord,
No,
within
it is
30
not
days.
last date. Last date is
My lord,
last date
notice is of
15.
13.
It's a premature case.
AG is there, he'll take care till day after tomorrow. Tomorrow is, we don't have any problem.
Because tomorrow the Panchayat and once the division
Okay.
bench matter is.
Day after tomorrow,
Yes, yes.
just ensure that nothing happens till
Now,
day after tomorrow.
Still, we cannot because our impute notice says 30 days
Okay.
time. 30
Paucity of time,
Okay.
paucity of time may not allow the matter to be taken up for consideration today. Full stop. This court has, however, been informed by the learned AG that pleadings have been exchanged and the matter can be taken up for final disposal at the motion stage itself. Full stop.
Deeply.
Para, as agreed to by the parties, comma list for consideration.
But
on-
tomorrow at 2 o'clock, I have no difficulty.
Depending what Master Mahanta, how long Mr.
Yes.
Mahanta will take. Yeah, tomorrow also. Let's try
take, well, I have
tomorrow. Please take it tomorrow. We'll have it at around 2 o'clock. Hello, Duta matters. Is it urgent, Mr. Sarania?
Maybe, my lord,
Wednesday?
Thursday will be better, but because.
Thursday?
Thursday.
Whatever, whenever is it? Thursday. Who's for the other side? Thursday, who's for the other side?
I am for the others.
Okay. What is the matter?
I'm for the caveator matter. That's what I'm
What is the matter?
Matter regarding, my lord, the dispense of, my lord, the impugn order by the state level scrutiny
Cancellation
committee,
of
my
the
lord.
caste certificate.
That holding that the
Okay.
respondent number petitioner is not
You have
belong to, my lord.
gone through the rigors of the case law, the requirement.
My lord. That in violation of the Madhuri Patil's direction. they will my lord.
Committee has looked into as per Madhuri Patil.
Not according to the my lord, direction of the Madhuri.
Okay, well, Thursday. Paucity of time will not allow the matter to be taken up today. Courts of, in the interest of justice, list, and on as agreed to by the parties, list for consideration on, list for motion on Thursday. Date. Mr. Chaudhary.
I love it.
Some urgency is there.
Yes, madam.
What is it?
Kali no, madam. Kali. Tomorrow it can be.
Okay, tomorrow. Tomorrow for motion.
Madam, preferably in the second half. Okay, let it be tomorrow. We'll see.
Tomorrow we'll accommodate you
Yes,
whenever you come.
yes, let it be
Okay.
tomorrow.
Same, huh? As agreed to by tomorrow. What was the matter?
Eviction
From?
land, madam.
No, no,
Actually,
from where?
we say that rule 18(2) could not have been invoked because madam, these are ceiling surplus land. It's not a government cast land.
Okay, which part of the state?
Sibsagar, Amguri.
Not Silsako. Okay.
My lord, I have two matters, item 33 and 35. Interim is there, shall be considered.
33 and 30. When do you want next week?
Yes, after 10 days or something.
33, 35. Paucity of time, 10 days. Interim order passed earlier, if any, stands extended till the next date of listing.
Item number 36, any date, Lordship, it is.
He'll give it.
Lordship, in item number 38, there is an interim order.
38 to interim. Okay.
All right.
Any matters, urgent matters, our court must give the date.